appeals that we have presented material issues of facts and law. We've done so in briefs, in oral arguments, in motions, and yet our core concerns are that they have never been acknowledged, considered, or adjudicated, not once. When such omissions are no longer isolated, they create more than the appearance of bias. They threaten the rule of law itself, and that's why we raise due process violations.
Dr. Bush, let me just briefly interrupt you so
Yes.
the record's clear. That in your filing, you specifically said that you were not filing a motion for recusal.
That is correct, sir.
All right, go ahead.
Yes, Your Honor, yes. And you acknowledge that, Judge McBrayer. We have laid out our issues clearly in our judicial notice that is contained within our brief that we submitted to you. My wife and I appear here today on appeal because our cause of action of a fraudulent breach of contract by Reliant Bank was dismissed by the Williamson County Chancery Court again, as it was in 2017, without any consideration of our claims. That dismissal was made under Rule 11.02 and 03 and was based on the claims and motion by opposing counsel, Mr. Montgomery. He said that our claims were frivolous and vexatious because, according to him, they had already been adjudicated in prior proceedings. But that claim is blatantly false. It is not only false, but it was unsupported and unproven at the time it was made. Mr. Montgomery did not show, nor was he required to show, where our claims for a fraudulent breach of contract have ever been adjudicated. In fact, when we filed the case on March 28th of last year, he still has not answered that claim, which is required to be answered in the next 30 days. He filed with the Chancery Court 16 exhibits, and I brought those here today. 16 exhibits, I guess 300 or 400 pages. I've read through each one of them. And this exhibit is from the record. It's now on the record with the court. And it's from the previous deficiency judgment prior suit proceeding. And the claim is that these exhibits prove that our current claims of this fraudulent breach of contract have already been litigated and adjudicated, but they do not. And I challenge anyone to go through here and see where our claims for a fraudulent breach of contract have been adjudicated. They do not exist. He did not show the court where in these 60 exhibits our current legal claims were addressed. The Chancery Court, never required such a showing, nor has he ever answered our complaint because he cannot, and he's refused to do so. These exhibits are now our proof that the claims within our judicial notice have never been addressed, never considered, and never ruled on. And if necessary, we're prepared to go through them page by page today, but that would take a while. Or Mr. Montgomery could show us in his allotted time specifically where those claims have been adjudicated, because that is the basis for dismissal of this case. Now, due process doesn't have any time limitation, and there is no time limitation when fraud is involved. In U.S. versus Throckmorton, they stated that fraud vitiates the most solemn contracts, documents, and even judgments. The Seventh Circuit has also stated that a decision produced by fraud upon the court is not in essence a decision at all and never becomes final. Now, as an attorney, and not me, an officer of the court, Mr. Montgomery is once again, and I hate to say that, and he can defend himself, but he's trying to deceive the court. Judge McBrayer, you also referenced our original case in your footnote, that taken in 2017, which was Bush v. Commerce Union Bank. It's been referred to as Bush 2. I'm getting famous off these Bush 1, 2, 3s, and 4s, so forgive me. You correctly noted in your order that this appellate court upheld the dismissal in that matter, not on the grounds of res judicata, which is being claimed again and is being repeated, but rather the dismissal was upheld in 2017 for prior suit pending. That's crucial to this appeal. Why? Because it affirms that the current appeal involves a new cause of action, distinct and separate from Reliant Bank's prior suit deficiency judgment action. Stated plainly, the prior suit deficiency judgment action was a debt collection and enforcement matter initiated by Reliant Bank against my wife and me. The current action is a claim by us, the appellants, alleging a fraudulent breach of contract by Reliant.
Dr. Bush, was there something that prevented this claim from being raised earlier? And you mentioned Bush 1, Bush 2, Bush 3, Bush 4, and is there some basis upon which your current claim could not have been raised at an earlier point? You're saying it's a new cause of action, a new claim, and was there some previous barrier?
I'm not going to necessarily speak to the barrier, or I'll perhaps, but yes, we did raise the issue. We did raise the issue. In fact, credibility has been brought up in the prior two cases, and we had a 4-day trial. And the sitting judge at that time of the 4-day trial.
Excuse me, was this in Bush 1?
Yes, sir. This would be in,
Okay.
yes, Your Honor. I'm sorry, I'm
That's
used
fine.
to saying yes, sir, and I don't mean any disrespect by that.
I take no offense.
We were found to be, the testimony of my wife and I were found to be not credible. And yet, in that opinion and order, every bit of evidence that is in our judicial notice was omitted. There are only two places, I'm going to deviate from this a little bit. There are only two places, and this would go to this over here, and Judge McBrayer, you may remember this because you heard Bush 3, and we brought this in, and you don't, I'm sure, because there's 100 things you do.
I can barely remember what I had for
All right.
breakfast this morning, so.
All right,
yeah.
okay, good enough. So we brought this in, and this is a direct representation of Reliant Bank's and I repeat that, multi-purpose note and security agreement. Multi-purpose means that they can use the same document for loans to a borrower only, a borrower with a guarantor or a cosigner, or a borrower that is secured by real estate. So the two items in yellow are paragraph 19 and the third-party agreement. Paragraph 19 says this: if this loan is secured by real estate, then the remedy for default, let me read it, I better do it correctly. If it is secured by real estate.
Hey, Dr. Bush, if you don't mind bringing it with you to the podium there, and you can read it from there, but if you're over there, the mic will not pick it up.
I get it, forgive me. Paragraph 19 says, if this loan is secured by real estate or residence, that is personal property, a default and your remedies for default will be determined by the terms of any separate document creating the security interest, applicable federal or state law, and to the extent permitted by law, and not contrary to the terms of the separate security document. The separate security document was the third-party agreement that said, I own the property described in the security section of this note and security agreement, and I agree to give you a security interest in that property. We put up a $2.4 million piece of property against a $1.5 million loan. It states I am not personally liable for payment of this debt. If the borrower defaults, my interest in the secured property may be used to satisfy, not offset, satisfy the borrower's debt. By signing, I agree to the terms of this note and security agreement and acknowledge receipt of a complete copy of this loan.
Wasn't this what was tried in Bush 1?
Well, it only is if you consider that by leaving out paragraph 19, which is only one of two places where real estate is mentioned, where default is mentioned, and where a remedy for default is mentioned, and securing the loan are mentioned, that's the only places in those two paragraphs in Reliant's multi-purpose note and security agreement. It's the only place where those are mentioned.
But wasn't this the issue in Bush 1?
Well, the issue in Bush 1 was a deficiency judgment.
And you disagree with what the trial judge did and what I think was affirmed on appeal.
And we filed motions to alter and amend, but that was left out. And when you take, if you have an equation, 5 plus 4 plus 3 plus 2 plus 1, you get 15. But if you leave 5 out, you only get 11.
Dr. Bush, didn't you have an opportunity to litigate the argument, though, that you're advancing? I mean, if the language here, you think is inconsistent with what the trial court decided back in Bush 1, what was affirmed in Bush 1, and didn't you have an opportunity to make these arguments, present this issue, and why isn't it then res judicata? I mean, there's been Bush 1, Bush 2, Bush 3,
Yes, sir.
and
Yes,
and maybe they were wrong, and maybe you were right, and maybe the court was wrong. But isn't it at this point res judicata? It's been
No, sir.
decided.
Because there are different claims, there's a different cause of action, and there are different issues of facts and law. And the different issues of facts are the fact that the main fact that refers you for any default is found in paragraph 19. But instead of using paragraph 19, the court in Bush 1 used paragraph 3. Paragraph 3 is only saying I'm obliged to repay the loan. It mentions no real estate, no security, no default, none of that, no remedy for default. It is only there for a multi-purpose loan, so that if I go in to borrow $5,000, sure, paragraph 3 applies. I am fully indebted to that debt. But if I put up a $2.4 million piece of property, and I have had those discussions with the bank president.
Dr. Bush, we gave you a couple extra minutes there, but your time's expired. You still have your time for rebuttal.
Okay, thank you.
We'll hear from the appellee.
May it please the court, Steve Montgomery, and I represent the appellees in this case, United Community Bank, and certain of its former directors and officers. The trial court correctly held that the complaint the appellants filed in this case was frivolous and violated Tennessee Rule of Civil Procedure 11.02. Your honors have absolutely identified the issue in this case. The arguments that Dr. Bush has just made, the note he's just pointed out, all of those arguments were made at the 2014 trial. They were addressed by the trial court, specifically considered. On direct appeal, this court specifically considered them and affirmed the judgment of the trial court. The appellants simply aren't happy with the decisions of the courts. Ever since the direct appeal concluded, and that was in 2016, the appellants have continued to make these serial filings, raising the same issues over and over again to try to overturn the trial court's findings and conclusions from the 2014 trial.
Counsel, let's assume for purpose of argument that there's a new issue, a new cause of action. Does that matter anymore at this point? And is there anything here that could not have previously been raised, even if, and I can come up with a new argument 10 years later why I should win, but I'm still bound by the earlier decision. And do we have to match this and this exact argument, this exact issue, or at this point does res judicata bar, even if it is a new cause of action or a new claim?
Your Honor is correct. Even if there was some claim that was not actually raised in 2014, res judicata prevents it. And that's, my next point is that any of the arguments that were made or raised, they don't relate to any conduct that took place after the 2014 trial, and that's an important, that's the key date. It's August and September 2014 when the trial took place. There are allegations that, for example, the appellant's testimony at trial was misleading or false. There are allegations, of course, the note's non-recourse, or that the bank didn't bid fair market value at the foreclosure sale. But all of that took place either at the trial or beforehand. And that leads to one of my arguments is that the current complaint, which was filed in March 2024, is frivolous because no matter how the cause of action is characterized, whether it's characterized as fraud or breach of contract or whatever it may be, the statute of limitations long ago ran on any of those claims. The trial court correctly determined that the complaint's frivolous for 3 reasons, and I've touched on one of them, and I think Your Honors touched on one of the other ones, and that is that issue and claim preclusion prohibit the appellants from continuing to relitigate these issues and these causes of action, no matter how they characterize them. And I think it's important to point out the appellants admit in this complaint that is before the court now that that's what they're doing. Paragraph 5 of the current complaint, I'm going to quote from it. It says, venue is proper in this court pursuant to Tennessee Code Annotated Section 20-4-101A, in which this countersuit was originally filed as case number 43362, but was dismissed from being heard concurrently with the prior suit. I believe that was Bush 2. And so the next paragraph of the current complaint, paragraph 6, says this counter complaint for fraudulent breach of contract was then timely refiled as case number 44489, but was again dismissed by the trial court for res judicata. And that's in the record at pages 1 and 2. So by the appellant's own admission, they filed this exact complaint at least twice before and had it dismissed twice. And you combine that with the fact that the appellants had the opportunity to raise all of these issues at the 2014 trial, and that completely bars them from proceeding in this action and expecting a different outcome. The third reason the complaint's frivolous is that it's barred by the saving statute of Tennessee Code 28-1-105A. As mentioned, the appellants voluntarily dismissed their first countersuit on September 10th of 2014, Bush 2. That didn't get appealed. So under Section 28-1-105A, they've got a year to refile their claims. And they knew that because they filed the second countersuit, Bush 3, 1 day before that 1-year limitation period ended. So that's September 9th of 2015. But that second countersuit gets dismissed under Rule 12, and that operates as a dismissal on the merits, and it precludes them from coming back 9 years later and trying to take another bite at the apple. The complaint never should have been filed, and it could never succeed for at least 3 independent reasons, as pointed out. And though the appellants are not represented by counsel, they were given fair warning and a 21-day opportunity to withdraw their claims as Rule 11 requires. They refused to do so. So the trial court imposed 3 sanctions. 1, dismissing the complaint. 2, awarding attorneys' fees and expenses. And 3, prohibiting the trial court clerk from accepting any additional filings from the appellants that relate to these same claims against United Community Bank and its officers, which have been repeatedly dismissed. These sanctions were reasonable and appropriate to deter the appellants' meritless serial filings. I've addressed the first sanction, dismissal of the complaint, and I don't plan to spend much time on the attorney's fees issue because it's relatively modest. But I want to touch on the third sanction, which is the pre-filing screening mechanism. About 20 years ago in the Hooker versus Sundquist case, this court affirmed a similar sanction under Rule 11 against attorney John J. Hooker after he filed his 4th nearly identical meritless lawsuit. The court recognized the danger done when, quote, a single litigant is permitted to glut the judicial system by filing essentially the same lawsuit over and over as long as there is breath in his body, end quote. That's what's going on here. The appellants have proven that they will just disregard any adverse court decision and continue filing the same lawsuit over and over until they're stopped. The trial court correctly recognized this and imposed the least restrictive sanctions that were necessary to deter these appellants' continued abuse of our court system. To conclude, as the trial court wrote in its order imposing sanctions, enough is enough. There is no fraudulent conspiracy to deprive the appellants of their day in court. The appellant's campaign of harassment and bad faith frivolous litigation must end. It is this court's obligation to say so and enter the appropriate order. Now, just as the appellant's complaint was frivolous, it was equally frivolous for the appellants to appeal the trial court's reasonable and appropriate sanctions. So the appellees respectfully request that this court affirm the judgment of the trial court, find the appeal to be frivolous, and remand to the trial court for determination of the amount of appellate attorney's fees to be awarded to United Community Bank. And unless you honors have further questions, I'll yield the rest of my time.
I hear none.
Thank you, Your Honor.
Dr. Bush, we'll hear from you in rebuttal.
I would begin by asking the question, is it frivolous if in Bush 1 we sat through a court session and the evidence came out and it's contained in the contract and it is contained in testimony by Reliant Bank officers that not only did they discover the third-party agreement and determine it to be a mistake in 2011, but then they withheld, the testimony clearly shows that they withheld that information. They didn't tell the Bushes that they considered the security agreement to satisfy our debt was a mistake. They didn't tell us that in 2011. Then they altered the documents when we renewed. They slipped it out. That is the only page of the document that does not have my initial. They did so knowing that it would cost us a deficiency judgment. I haven't heard Mr. Montgomery tell us where paragraph 19 has been adjudicated. I haven't heard him tell us where, if anywhere, that the testimony by Reliant Bank that the security agreement was a mistake, their mistake, not our mistake, that they knew about for 4 years but didn't tell us and wouldn't have told us if we had asked, and then made it a point to ensure that we did not renew the separate security agreement, knowing that it would cause us $1 million in a deficiency judgment. I haven't seen in one single opinion, one single order, or one single judgment where that information has been considered. So my question is it frivolous and vexatious if you go to an honorable court and you know you're going to win because in depositions they've already testified that they considered it a mistake, but you get in there and the court does not even acknowledge it, does not address that, so you come back and you ask a motion to amend. The motion is dismissed. You file a countersuit specifically for this information. It is dismissed by the same judge.
Dr. Bush, did you present all of this information that you're presenting or that you're trying to present now to the trial court in earlier proceedings?
Yes, sir.
Okay, so it's all been presented before.
Yes, Your Honor.
This has been properly considered.
This is presented. This has been presented.
Okay.
But I would contend that presenting evidence and having it considered, legally considered and adjudicated, are not the same things. And I would contend that it is not frivolous for us to fight for what we know is right. And when someone has testified that they knew about it and didn't tell us and wouldn't have told us if we had asked, I contend there is nothing frivolous or vexatious. And all of the appeals have not been ours. He has appealed when it went against him in Bush 2. I'm sorry, Bush 3, forgive me. In Bush 3, it went against Reliant Bank. And they appealed. And we made the opportunity, we made the offer less than a year ago to just settle and walk away. We would walk away from this and end it. We don't owe you, you don't owe us. That was given at 7 o'clock in the evening, if I recall, in an email from Mr. Montgomery, and 9 o'clock the next morning, we had a denial. He left it aside. So I would contend it is not frivolous or vexatious to seek justice. Yes, sir.
I was going to tell you to wind it up because your time has expired.
Yes, sir. So, due process calls for the fair and equal adjudication of the issues of facts and law. If it's anything less, it's not due process. We have the 16 exhibits.
Dr. Bush, your time's expired.
Oh, thank you. Thank you, sir.
We appreciate your argument this morning. You all, Ms. Bush, Dr. Bush, you all may already know, but the way the process works now, I always say this to individuals representing themselves, make sure that they fully understand what the process is from now. We'll take the case under advisement, review the record, review the briefs, and then we'll issue a written opinion, and it will be sent to you on both sides at the same time.
Yes, thank you so much.
Thank you.